Okay, you may proceed, Mr. Mokoena.
Thank you, Mr. Chair. Mr. Sinton, before the tea adjournment, you were dealing with your meeting, with the Standard Bank meeting, the meeting between Standard Bank and Oak Bay representatives. Is there anything that you need to add? Yes. Now, can we move on to the meeting which you mentioned?
I'm sorry, Mr. Mokoena. I think he must just repeat that answer. I think his mic was off, so it goes into the record.
Mr. Chairman, yes, I have nothing more of particular importance to say about that meeting.
Yes. Now let's move to another meeting which you mentioned in passing before the tea adjournment. You referred to the meeting which was held between Standard Bank and the NEC of the ANC. Am I correct?
That is correct.
Yes. Who called that meeting?
My understanding, it was a request from the Secretary General of the ANC, Mr. Mantashe, made to Mr. Sim Tshabalala, who is the Chief Executive of Standard Bank.
And then where was the meeting held?
At Luthuli House.
Who represented Standard Bank? If you are able to recall.
The Standard Bank was represented by myself, Mr. Sim Tshabalala, and Ms. Hannah Siddiqui, who was a senior executive in our retail banking division.
And then ANC was represented by who?
ANC was represented by Mr. Mantashe, Ms. Jessie Duarte, and Mr. Enoch Ngodongwana.
Prior to attending the meeting, were you told as to what was the purpose of the meeting?
I was told it was to discuss the notice of closure of the Gupta-related accounts.
Now, could you please tell us what happened in that meeting?
When the meeting commenced, after we had exchanged the normal pleasantries, we made it clear to the ANC representatives that we were not in a position legally to discuss the affairs of any of our customers, and in particular we were not in a position to discuss the Gupta-related entities, the Oak Bay companies, or our reasons for closing their accounts, but we were willing to explain our policies and procedures around account closing generally. And the ANC representatives seemed to accept that would be an appropriate way to proceed with the meeting.
And then what happened in the meeting? Can you share with us?
Well, I then explained to the meeting essentially what I explained to the chairman here about the local and international obligations that we have, about our processes when we come across adverse information and how we make our decisions. I also took the opportunity to highlight the real risk for us. We had an unfortunate experience where our bank in Tanzania, whilst it was negotiating to get a mandate from the government, employed a local partner that was partly owned by a politically exposed person, which is the term we use in these issues. And the partner, the mandate was awarded, the partner was paid its fee in US dollars, and the partner, being a corporate partner, withdrew that fee in cash. As a result of that fact alone, the Serious Fraud Office in the United Kingdom opened an investigation of corruption against us, and the Department of Justice in the United States opened a case of corruption against us, based simply on the fact that a local partner had been employed. And we explained that we cooperated with both the Department of Justice in the United States, we cooperated with the Serious Fraud Office, and the result was a deferred prosecution agreement, which is effectively a settlement agreement with the authorities, whereby we ended up paying about $38 million in penalties and fines for simply having employed a local partner, and that deferred prosecution agreement had to be approved by the courts in the United Kingdom. And the judge who approved it said that the prosecution was justified simply on the basis that our staff should have foreseen the possibility that their local partner, being part-owned by PREPS, would be sharing the fee with people in government. We should have foreseen that as a possibility and therefore not employed them at all. The fact that we employed them rendered us guilty, as far as they were concerned, both in the United Kingdom and the United States. So I explained this to the meeting, and said we therefore are highly sensitive to the possibility of dealing with people who could be using our systems and facilities for gratification. I think the term is in the local term. But having explained all of that, the meeting then did go on to talk about the issue of the close of the Gupta accounts. We were asked to comment on the perception that we were part of white monopoly capital oppressing black business. We were asked to comment on the reports that we were taking instructions from people in Stellenbosch in closing these accounts. And we obviously rejected those out of hand. I must say it's the first time I've seen my boss, Sim Shabalala, get really angry. We were then also asked to comment about the concerns that these account closures might have for the employees, i.e. The inability of the Oak Bay entities to possibly pay their staff could affect the staff adversely, and we needed to comment on that. And I think our answer at the time was the fact that we were simply complying with the law and taking necessary steps to protect us. And the point that I think Sim made at the time was we employ 40,000 people. Our staff are equally important to us. And we can't do anything that is contrary to the law here and exposes us to international sanctions.
Yes. After the meeting, you did send a letter to the ANC. Am I correct?
Yes, we did. The entire meeting was oral. There were no presentations made, no documents exchanged. So we thought it appropriate to send a letter just to summarize what we had said in the meeting, so we both had a clear understanding.
May I refer you to page 138 of Exhibit H1? Are you there, Mr. Sinton?
That is the letter that was
sent. Is that the
sent,
letter?
yes. Correct.
Yes. And the letter captures what you have already informed the chairperson in your testimony, briefly.
Yes, I believe it does, Mr. Chairman.
Now, you also mentioned in passing before the tea adjournment that Standard Bank was invited to the meeting by a committee that was chaired by Mr. Mosebenzi Zwane. Do you recall?
Yes, I do.
Yes. Now, how did Standard Bank became aware of the existence of the committee that was chaired by Mr. Zwane?
We received at Standard Bank an email from an advocate, Zarina Kellerman, who addressed to Mr. Ben Kruger, who at the time was the chief executive of Standard Bank Group, i.e. our group holding company, in which he said that she acts on behalf of an interministerial committee and that Ben Kruger was invited to a meeting to discuss the closure of accounts.
Did Standard Bank attend that meeting?
Yes, We responded by pointing out that Ben Kruger was not the appropriate person. This was a matter involving the Standard Bank of South Africa Limited, i.e. our South African bank, and the correct person to therefore engage with the IMC was Mr. Sim Chabalala, and he and I attended a meeting in Pretoria as a result.
And who represented the committee that was chaired by Mr. Zwane?
When we arrived at the meeting, there were 3 people attending the meeting on behalf of the IMC. There was Minister Zwane, Minister Olifant, and Mr. Jimmy Manye.
Was Mr. Jimmy Manye a minister at the time?
No, we asked on what basis he was attending, and he told us that he was an advisor to the ministers.
Did he remain in attendance throughout the meeting?
Yes, he did.
Now, were you informed as to how this committee was established?
The Minister Zwane introduced himself at the start of the meeting as being, he described that the committee had been formed by cabinet at the instance of President Zuma, and he had been appointed as chairman, and therefore he would be conducting the meeting in that capacity.
Were you informed about the agenda of the meeting?
We understood the purpose of the meeting to be to discuss the closure of the Gupta-related bank accounts. The meeting took place on about the 5th of May 2016, so it was during the period when the notice period was still running its course. So our understanding was it was to discuss the closing of bank accounts.
Could you share with the chair in your own words as to what happened during the meeting?
Mr. Chairman, we started the meeting by, as we had done with the ANC, making it clear that we're willing to discuss and explain to the committee the policies and procedures that we adopt as Standard Bank when we have adverse information in the public domain. And we, again, as we had done with the ANC, explained why, as Standard Bank, we are particularly sensitive to this issue. I might mention, because I omitted to say so earlier, that when we concluded the deferred prosecution agreement with the Serious Fraud Office in the United Kingdom, the charge that was leveled against our bank in the United Kingdom was that it had failed to prevent an act of corruption by an associate. So there was no allegation that Standard Bank London had done itself, was itself corrupt, but it had failed to prevent an associate from corruption. In the nature of a deferred prosecution agreement, the agreement sanctioned by a court says we will allow you, the agreement is you will pay a voluntary fine, you will compensate all people who have been, who have suffered loss as a result of the conduct complained of, and you will undertake a remedial program to ensure that this type of conduct never happens again. And if after 3 years you are not charged with a similar offense, then the charges will lapse, i.e. it's a non-prosecutorial outcome. It's as if the charges had never been laid. So our bank in London had this 3-year probationary period where it had to be exceptionally careful about what it did and said in connection with bribing corruption, and it had to be very careful to ensure that its associates did not in any way become accused of bribing corruption. Now, there's such a close relationship between all of the banks within the Standard Bank Group that it would be not difficult to argue that our bank here is an associate of our bank in London. So we had to be particularly careful about not being caught up in bribing corruption in South Africa. And I explained all of this to the IMC, and they they accepted those explanations. However, once I had given that explanation, they turned almost immediately to the Oak Bay entities and the closure of the accounts. And the point they made, they said that Oak Bay has, they claimed, had about 7,500 employees. They say you can safely assume in South Africa that most employed people have more than 5 dependents, and therefore up to 60,000 South Africans, they said, could be, if this decision was implemented, adversely affected in that they might be deprived of income or payment. And we should, as a responsible bank, be sensitive to that and should reconsider for that reason. And our response was to say we really are doing no more than complying with what we think is a very onerous law. We really are very concerned if people should be affected by those decisions, but it's really the conduct of the owners and managers of the business that have brought into that situation, not us. So that was the one representation they made. In that same line, they said, well, surely if it's a contest, as it were, between the well-being of the employees and their dependents or compliance with the law, we should favor the dependents, i.e. we should keep the accounts open to enable the dependents to be paid and risk non-compliance with the law. That was the proposition they put to us. And we said we couldn't accept that. We wouldn't accept that we would knowingly break the law in order to ameliorate the consequences of non-payment of employees. They then suggested that the banks should not be allowed to close bank accounts altogether, i.e. they said they had the power to change the law and that they would consider recommending changes to the law to make it illegal for banks
Who said
to close
that?
accounts. Minister Zwane. Minister Zwane in the meeting.
Can you repeat, what did he say?
He said that as a member of the ruling party, he had the ability to get the law changed, and he was inclined to propose a change in the law whereby it would become illegal for banks to close accounts in these circumstances.
Yes.
And who said that if, in effect, you had to choose between not complying with the law and having workers lose their jobs, you should not comply with the law, if I understood your evidence correctly?
Mr. Chairman, regrettably, I can't remember which of the two ministers said that, but that was the proposition put to us.
But it was one of the ministers.
That is correct, Mr. Chairman.
Thank you.
Yes, Mr. Sintin, proceed then. Share with us further engagements between yourself and the committee in that meeting.
I think I've already mentioned we were asked to comment on the allegation that we had colluded with the other banks in closing accounts, and we said that definitely was not the case. We were asked to comment on the allegation that we were representing white monopoly capital in closing accounts, and we rejected that. We were asked why it is that we bank construction companies that have been fined for collusion in the building of soccer stadia, yet we close the bank accounts of entities that have not been convicted of any offense. And we responded by saying that we didn't admit or deny that we did bank any construction companies, but we would regard an administrative fine for collusion as something quite different to money laundering or corruption. Towards the end of the meeting, they reminded us that as a bank, we operate under a license granted by government, and that they suggested we should be more responsive to concerns that they were raising on behalf of government.
Do you recall as to who said that?
Mr. Zwane, that was his submission.
And what was the response from Standard Bank when you said that?
We said as far as we are concerned, we comply with all of the laws of the land to the best of our ability at all times, and if the law should change, we would adapt. So in summary, that was really the tone of the meeting. The meeting ended with Mr. Zwane, or Minister Zwane, asking us what changes we would need to see within the ownership and management of the Oakbay Group of companies that would be sufficient to persuade us to reverse our decision to terminate the accounts.
So despite you having informed Mr. Zwane that you are not at liberty to discuss that customer relationship with the IMC, he continued to put those questions to you?
That is correct.
Now, after the meeting, what was...
I'm sorry, Ms. Mukwana, and what was your answer? I didn't hear in terms of that last question from Minister Zwane.
Mr. Chairman, our response was to say that we had taken the decision based upon the facts as presented to us, that if circumstances should change or facts could change, we might have to make other decisions, but at that point in time, we were operating on information at hand.
What impression did you gain after this meeting, Mr. Sinton? You must have reflected about what transpired in the meeting between the Standard Bank and IMC. What impression did you gain about this meeting?
The meeting was an attempt by two cabinet ministers on behalf of cabinet to persuade us to retract our decision to close the accounts of the Gupta-related entities. There was no other reason for that meeting.
And if your analysis of the discussions, or rather, if your analysis of the purpose of the meeting is correct, then the position might not only be that two cabinet ministers wanted a meeting with Standard Bank to try and get Standard Bank to reverse its decision, but it might mean that if that committee was established by cabinet, it might mean that cabinet wanted a meeting with Standard Bank through that subcommittee to achieve a reversal of Standard Bank's decision in the particular matter. Is that right?
That would be correct, Mr. Chairman.
Now, were there any minutes which were taken during this meeting by the committee?
Advocate, or she was described as Advocate Kelly, the secretary to the committee, was present throughout. She seemed to be taking notes, but after the meeting, no notes were, or minutes were circulated at all. We were concerned that this was, in effect, a meeting between Standard Bank and a subcommittee of cabinet, and therefore it ought to be formalized in some way. And so we took it upon ourselves to, as we had done with the ANC, write a letter to the ministers to record what oral representations and presentations and explanations we had given during the meeting.
May I refer you to page 148?
Page
148, Mr. Chair. Would that be the email wherein you enclosed the letter on page 1, starting from page 149?
That is the email that was sent to the committee, yes.
And then in the email, you say that please find attached documents for attention of Minister Zwane and Oliphant. And what is attached is the letter on 149. Am I correct?
That is correct.
Now, Mr. Sinton, are you able to summarize without having to read the contents of the letter on page 149 as to what did you convey, or what did Standard Bank convey to Minister Oliphant and Minister Zwane?
It records in more detail, Mr. Chairman, what I've just described to you now.
Okay.
It upfront reminds the ministers that we had hoped to keep the meeting about policy and practice, not any particular customers, but we did go on to discuss particular customers. It summarized all the laws that we say are applicable to us and the risk we face if we don't strictly adhere to those laws. We summarized our experience of international views on dealing with bribery and corruption. And we then described our process and about what considerations we take into account when we make a decision to close, i.e. they're not arbitrary or capricious decisions, they're carefully considered. And effectively, we finished off with the wording where I say in response, when I say I was letter was signed by Sim Chabalala, I obviously had a hand in drafting it. In response to a closing query as to whether there is any possibility of Standard Bank reversing any decisions that could help save the jobs of the employers of Oak Bay / the Guptas, Standard Bank indicated that it applies the known facts and suspicions as envisaged by Precker and Poker to the law to reach its decisions, and therefore if the facts should change, there could be a resultant review. Consequently, the IMC requested, and Standard Bank indicated willingness that Standard Bank give consideration to informing the IMC in due course of what changes in ownership and or control of the Oak Bay Estate Gupta Group of companies could be required for Standard Bank to review any decisions it may have made. And then there's a sort of normal sort of
Yes.
caveat.
Mr. Sinton, this is quite a detailed letter addressing a number of issues. Was these issues that are contained in this letter at any stage disputed by Minister Zwane or Minister Oliphant or by anyone?
No, we received an email back from the Secretary to the IMC wherein she was asked to thank us for the input, and that's the only response we received to the letter.
Would that be the email contained on page 154?
It is.
Other than that short email, nothing was communicated to Standard Bank about the contents of Annexure SB 16.
That is correct.
Now, subsequent to that meeting, you would recall that there was a press statement or an announcement made by Minister Zwane. Do you recall?
I do recall that, yes.
Could you share with the chairperson what was contained in that media statement and what was the purpose of that media statement? You are dealing with it from page 11111, paragraph 31.1 to paragraph 31.5 of your statement. If you can summarize for us what was conveyed in the press or in the media statement.
Did you say 121?
111, Mr. Chair.
Sorry?
111.
Oh, thank you.
Yes. In 111, on page 111, is my summary, my witness statement of, well, I quote the extracts from the statement, Mr.
Yes,
Chairman,
if you
but
can.
if you look at page 142 of the bundle, you'll see the statement itself.
Yes.
Where of relevance to this discussion is where it was said on behalf of the Department of Mineral Resources that on 13 April 2016, Cabinet established an interministerial committee to consider allegations that certain banks and other institutions acted unilaterally and in collusion when they closed bank accounts and or terminated contractual relationship with Oak Bay Investments. That was the purported purpose of this meeting. And then they go on to make recommendations for a judicial commission of inquiry into the closing of accounts and various other things.
And this was coming from the office of Minister Zwane.
Yes.
Subsequent to this statement that has been made, we now know, when reading your witness statement, that there was a media statement made by the then President Zuma in relation to the contents of the statement made by Minister Zwane. Do you recall?
I do recall that, yes.
And can you share with us what was conveyed in that media statement?
Yes. On you'll find the actual statement at page 155 of the bundle.
Annexure SB 18.
Mr. Chairman, where you'll see it's a statement. The heading is Statement of Minister of Mineral Resources is not government position. And the heading is the Presidency wishes to assure the public, the banking sector, as well as domestic and international investors of government's unwavering commitment to the letter and spirit of the country's constitution, as well as in the sound fiscal and economic fundamentals that underpin our economy. And they're going to say that the statement issued by the Minister of Mineral Resources, Mr. Zwane, yesterday on the work of the task team established to consider the implications of the decisions of certain banks and audit firms to close down the accounts and withdraw audit services from the company named Oak Bay Investments was issued in his personal capacity and not on behalf of the task team or cabinet. That was.
So the President there was repudiating the media statement that was made by Mr. Zwane?
Yes, that seems so.
Is it your understanding too that the statement that was issued by the presidency at 155, while it may have repudiated the statement, media statement issued by Minister Zwane, it acknowledged that he was a member of the task team? Well, maybe I can help you if you look at the third paragraph of the statement. The paragraphs are not numbered. It says Minister Zwane is a member of the task team.
That is correct, Mr. Chairman.
So it appears that officially the statement doesn't deny the existence of a task team as such, but it repudiates the media statement that was made.
Yes, that was our interpretation of it, Mr. Chairman.
Thank you.
Now, Mr. Sinton, having gone through your statement and the annexures and provided oral testimony before the chair, are you aware, and I'm asking this question flowing from your experience within the banking sector, whether are you aware of any provision in the Constitution that could have entitled the executive to interfere with the bank-client relationship?
I certainly am not aware of any statute or law which allows for it. And I would assume that the provisions of the Executive Members Ethics Act, which prohibit executives from using their powers to benefit any one person, would in fact prohibit it.
May I refer you to page 115 of your statement? in order to conclude your evidence. In paragraph 39.1 on page 115, you state that where Standard Bank has terminated its relationship with the Gupta entities in order to avoid contraventions of and therefore in compliance with legislation, not any minister or executive or any judicial commission or inquiry can lawfully direct that the terminated relationship be reinstated. And you confirm that?
I can confirm that.
Yes.
I must hasten to add that I do say at the outset that what I say about legal conclusions is based on legal advice, but I do say that.
Mr. Sinton, please try and raise your voice again. I think it's natural. Sometimes one speaks at a certain level and then later on goes down. But if you do no more than what you did earlier on when I asked you to try and raise it, that would be enough.
Thank you, Mr. Chairman. I will.
Thank you.
Must I repeat my answer, Mr. Chairman?
No. That's fine. That's fine.
Lastly, Mr. Sinton, you annex to your statement, may I refer to page 158, where you are annexing the transcript of the proceedings of Parliament. And this will also assist in clarifying the questions that the chair was posing around Mr. Zwane's involvement as the member of the IMC. Now, without having to read it, Mr. Sinton, you have dealt with this in your statement. What was the purpose of you annexing that transcript? What does it convey in the light of the issues that you wanted to convey to the chair?
Mr. Chairman, I have already given evidence and we've discussed how we were invited by the IMC to a meeting. Mr. Zwane, or his ministry, then issued that statement saying that the recommendations of the IMC to Cabinet had been accepted and what those recommendations were. He was then repudiated to a degree by the presidency. When we were faced with the application by the Minister of Finance in the Pretoria High Court for his declaratory order, we gave consideration to whether we could regard the workings of this interministerial committee as having come to an end or been rendered of no relevance to us by that repudiation. And in our research, we obtained this transcript, which is a transcript of the goings on in Parliament in November 2016. And our interpretation of the questions posed to President Zuma at the time and his reply was to the effect that whilst Minister Zwane had been repudiated for having issued that statement, the recommendations of his interministerial committee were still being considered by him as president. And we could still, in due course, expect to receive some other response. And so the purpose of referring to it was simply to tell the court that it may have been at the time not the end of the matter as regards the meetings with the interministerial committee and its recommendations.
Mr. Chair, for completeness, Mr. Sinton is dealing with those aspects from page 114 of his witness statement, paragraph 37 to paragraph 38.
Thank you.
Subject to any questions from the chair, though that concludes the questions for Mr. Sinton.
Maybe just one question, Mr. Sinton. Are you aware whether Minister Zwane had ever said anything in public about his statement that had been repudiated by the president, or he didn't say anything publicly that you are aware of?
Mr. Chairman, the only public statement I'm aware of, you can find at page 156 of the bundle. That appears to be a report in City Press on questions and answers in Parliament, where the report, if two-thirds of the way down, says that Presidency distanced itself from Zwane's statement, saying he had issued it in his personal capacity and that the contents of the statement were not the government's position. DA MP David Mania asked Zwane whether he would resign from the cabinet and when he would do so. Zwane would not answer the question directly. He said in terms of the principle of separation of powers, the matter belonged to cabinet and not to Parliament, adding that Mania had no jurisdiction to ask him whether he would resign. And then they purport to quote from Mr. Zwane, as I stated during my interview with the SABC, I stated that the matter of inquiry, which Mania seems to be problematizing, can only be decided by the President once he has sufficiently applied his mind to the matter. We have been a record in this matter. It is indeed unprecedented that banks can unilaterally close accounts. The matter can therefore not be left hanging, said Zwane. That's the only public commentary I'm aware of.
Thank you very much. Thank you, Mr. Sinton. You will be released for now, but it's likely that the legal team may ask you to come back at some stage. But thank you very much for coming to give your evidence in the commission. Thank you very much.
Thank you, Mr. Chairman.
You are excused.
Chair, the next witness has been arranged for tomorrow morning. Would it be appropriate to adjourn?
Yeah, that's fine. We will then adjourn the proceedings, and as I indicated, tomorrow we'll start at 11:30 and not at 10, as we normally do. The proceedings are adjourned.